Planning for a diverse family, cultural competence within the model rules. That is the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC fellow host with today's topic.
This is ACTEC fellow Connie Eister of Boulder, Colorado. Cultural competency is a critical skill for estate planners seeking to effectively serve today's increasingly diverse client base. In this episode, we examine how cultural awareness enhances client relationships and supports ethical, inclusive planning. ACTEC fellow Ritu Pepoff of Chicago explains how the ABA Model Rules of Professional Conduct provide a framework for navigating cultural considerations and provides real-world examples that highlight the importance of sensitivity and adaptability in estate planning. Welcome, Ritu.
Thank you, Connie. The reason that we're talking about this today is because it's important to recognize how a client's cultural background and personal values can really influence how they approach estate planning. Different cultures have different traditions, beliefs, and values around family dynamics and around wealth transfer, which need to be considered in order to create an effective and meaningful estate plan. And it's important that estate planning attorneys practice cultural competence when representing clients so that the estate plan can address not only the financial and tax aspects, but also honor the client's cultural heritage and their personal wishes. So, to make sure that we're all starting from the same point, we do need to define certain terms we're using here, like culture and competence. So, when we're talking about culture, we're talking about the shared customs and traditions and social norms of a particular group of people. It's the way that our attitude towards family, inheritance, and responsibility shapes our decisions. For example, favoring extended family or prioritizing care for elderly parents. But cultural norms can also affect how we communicate topics with family members. In some cultures, discussing death and financial matters may be considered offensive and discouraged. Other cultures may be more open and transparent to these topics. Now, when we're talking about competence, we're talking about having sufficient knowledge, judgment, and skill for a particular task. The ABA Model Rules of Professional Conduct, Rule 1.1, states that in an attorney client relationship, a lawyer shall provide competent representation to a client. And competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So, when we think about competency in the cultural context, it generally means that attorneys should understand and respect their clients' diverse backgrounds and values in order to provide effective and personalized legal services. So it involves recognizing and respecting the differences in beliefs, values, customs, and traditions of people from various cultures. Now, cultural competence includes four key components. The first is awareness. So, awareness of one's own personal biases to people who may be different. So, this first step really involves self reflection to help us become more conscious of our own stereotypes and our own culture and how that influences our behavior and our attitude towards others. So, it's being more aware of how cultural differences may have played a role in various interactions and how we felt about that or how we reacted to that. The second component is attitude. So, demonstrating openness, empathy, and respect for cultural differences. It's valuing diversity and a willingness to learn from others, and really seeing diversity as a strength rather than an obstacle or a challenge to overcome. The third component is knowledge. So, actually learning about different cultures. What are some of their values and traditions? And we can get this by studying different cultures or by attending cultural events or just by having conversations with people from different backgrounds. And then finally, the fourth component is skills. So, applying what you've learned so that you can have effective and meaningful conversations with people from different cultures. It's practicing empathy and being adaptable to different cultural interaction, picking up on nonverbal cues and responding thoughtfully. So, it's not just what you know, but how you use that knowledge. So, putting this all together, Cultural competence in estate planning is the intentional practice of understanding and respecting the diverse cultural backgrounds, beliefs, and values of a client when creating the estate plan. And it not only results in a more personalized and meaningful estate plan, but it also strengthens the attorney client relationship since the client will feel more respected and understood. So, looking at this in the context of the model rules of professional conduct, we know that Model Rule 1.1 requires that an attorney provide competent representation to their client, and that competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So, competence is more than just technical knowledge of the law. In advising a client about their estate plan, attorneys should recognize how cultural backgrounds shape clients' views on inheritance and aging and wealth transfer. Some cultures may prioritize family wealth preservation, while others may emphasize individual inheritance rights. In order to competently provide estate planning services in this multicultural society, we have to understand these cultural differences. And by integrating cultural awareness in our day to day practice, estate planning attorneys can fulfill their ethical duty under Model 1.1 and provide competent and inclusive representation. Now, Rule 1.4 of the model rules relates to communication. So, Rule 1.4 requires estate planning attorneys to keep their clients informed about estate planning matters, explain legal concepts clearly to enable clients to make informed decisions, and respond promptly to reasonable client requests. So, having clear and effective communication is critical in the legal representation because it ensures that the client fully understands their options and the implications of various decisions related to the estate plan. And effective communication goes beyond just translating words when someone speaks another language. It really involves ensuring that the client understands the legal advice you're providing. When there are language barriers, conversations with clients can be sort of jumbled and unclear, which then can lead to potential misunderstandings. And if clients don't understand key details or the implications of certain decisions, it can lead to the client making uninformed decisions that negatively impact their estate plan or don't actually reflect their wishes. For example, they might not fully grasp the risks associated with a particular estate planning strategy or the consequences of a healthcare decision. And these language barriers can also hurt the attorney client relationship, which is a relationship that is supposed to be built on trust. Clients need to feel heard and understood, and when clients can't express themselves freely or their concerns are not adequately addressed, they could lose confidence in the legal representation. So, estate planning attorneys must know how to effectively communicate with clients with diverse backgrounds and adapt their communication style to ensure that the client understands the legal advice, which can oftentimes mean hiring a professional translator for those clients who do not speak fluent English. Now, Rule 1.6 of the model rules provides that a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. Now, this rule plays an important role in culturally competent estate planning by ensuring that attorneys respect and protect client privacy, particularly when handling sensitive cultural and family matters. Some families may prefer strict privacy about inheritance decisions, while others may include extended family in these discussions. So, attorneys should create a safe space for clients to express their wishes without judgment or fear. And while Model Rule 1.6 mandates confidentiality, it also allows disclosure in specific situations, like to prevent harm or fraud. So, attorneys do have to balance cultural sensitivities with these legal obligations. So, it will be important for estate planning attorneys to educate clients on when disclosure may be required. So, putting all of this together really means that integrating cultural competence into estate planning isn't just good practice, it's actually an ethical obligation under the model rules of professional conduct. Thank you.
Thank you, Ritu, for helping us reflect on both the importance of engaging effectively and respectfully with clients and how that effort fulfills our ethical responsibilities under the model rules. It's such an important topic, and I really appreciate your time today.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review.